Major breaking news. As the positions of the United States Department of Justice under President Donald Trump are developing, it is pretty clear that attempts by certain states to try to ban so-called militia training, collective training of arms among we the people, is probably going to fall by the wayside. That's right. It looks like the Trump administration is using the Supreme Court precedent in a great way that ultimately will knock out any laws that attempt to prevent collective training with firearms in the so-called blue states and more. Let's break all this down when we come right back. Time to get geeky. Hey folks, I'm Mark Smith, host of the 4 Box of Don, a proud American gun owner, constitutional attorney. Member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. And I'm happy to report, as you know, the voting has now begun for the 2026 Gundies Awards for the top voice of the 2A, and I'm proud and privileged to say I've been nominated for that award again. So if you're so inclined and you're going to vote for the Gundies Awards, go over there to thegundies.com and vote for Mark Smith in the 4 Box of Donner in the category of top voice of the 2A. I would appreciate your support. Stiff competition over the next few weeks. You can vote once a day between now and December 15th. All right, so this is exciting news, folks. I don't think people have picked up on this quite clearly yet. And that is that the current position of the Donald Trump Department of Justice in some of the lawsuits, specifically in, for example, the Barnett case out of the U.S. Court of Appeals for the 7th Circuit, and impliedly out of the Cheeseman case in the 3rd Circuit. These are cases involving, among other things, AR-15 bans, bans on suppressors, and bans on magazines that hold more than 10 rounds. In particular, the Barnett case in the U.S. Court of Appeals for the 7th Circuit out of Chicago. That deals with the Illinois laws. Well, it turns out that if you look carefully at what the Trump administration has been arguing in support of the Second Amendment in those cases, it is clear it is giving rise, really a reaffirmation, if you will, of powerful Supreme Court precedent that would make it, in my view, unconstitutional for certain blue states to try to restrict collective training with firearms, so-called anti-militia laws, whatever you want to call these things. And in addition to the fact it probably would violate the First Amendment's right of the people to assemble, set that issue aside, and the right of free association, meaning the right to associate with people that you want to associate with, set aside those constitutional issues. It appears, based on the Trump administration's arguments, if accepted by the Supreme Court, and I think it would be because the Trump administration is relying on Supreme Court precedent, then indeed attempts by the blue states to restrict the ability of collectively coming together to train together for the purposes of becoming proficient in firearms, those types of laws should fall by the wayside as violative of the Second Amendment right to keep and bear arms. The reason why this is becoming an issue is many states are passing or have passed laws that basically say that types of training, now it's couched in different kinds of words here, and I'm not going to be geeky enough to break down every single one of these, but a lot of these kind of impliedly or otherwise suggest that you're not supposed to be working together or training together or collectively working together when it comes to being proficient with firearms, out of a fear that you might form some sort of a private militia, which arguably is unlawful, at least according to some of these state laws. Now, with that said, though, it seems to be a bit of a stretch that this could fly. Before I get to the Trump administration's positions and how, frankly, if adopted by the Supreme Court, it would knock out these kinds of laws, let's just think about this from a practical point of view as a constitutional litigator. To begin with, you think about the other constitutional rights where I have the right by myself to practice a right or to exercise a right, but I also have the same right to exercise that right with others. Let's just take the most basic ones. I have the right to petition the government by myself, by writing a letter to the congressman. We can petition the government together by writing a joint letter signed by many people to petition the government under the First Amendment. What I do by myself, I can also do with a group. So too with praying. I have the right to, pray to God, to Jesus Christ, so on, by myself. When I go to bed, let's say, by myself. In contrast, I can also pray in church or in a synagogue with other people. Again, I can practice my right to exercise a religion by myself or with others. So too, the right to free speech. I can stand out front of my state house with a sign up protesting gun control laws, let's say, Or I can get a group of friends together and we can go with placards and stand in front of the same state house together collectively and protest together. Again, another example of a fundamental constitutional right that I can legally do myself or with others. So too when it comes to the right to keep and bear arms. If I can engage in arms-bearing conduct by myself, and that is a phrase, by the way, from the United States Supreme Court, specifically the U.S. Supreme Court in the Rahimi case, literally refers to protections of arms-bearing conduct. Well, we know what that would mean, carrying a gun, possessing a gun, shooting a gun, training with a gun, and so on. All of what I just mentioned are forms of arms-bearing conduct. That is not Mark Smith and the Four Box of Diners saying it. That is the United States Supreme Court literally saying the phrase arms-bearing conduct is protected under the Second Amendment at the plain text level in the U.S. Supreme Court decision of U.S. versus Rahimi. So with that said, training by myself or with others is clearly a form of arms-bearing conduct. So too, if I want to practice with my firearm by myself or with others, just like any other constitutional right, both are equally protected under the Second Amendment. In addition to, of course, being protected, I would argue, under our right to free association, to associate with the people we want to associate with, as well as, of course, the right to assemble. Assembling means, by definition, you're assembling, you're coming together for a purpose. So with all that said, it seems to me that the right to train together collectively with others to practice proficiency in firearm use and arms-bearing conduct would be protected under many aspects of the Constitution, including the Second Amendment. Now, the Trump administration is basically adopting this view in various ways. And I'm not going to belabor the point here beyond simply referring to an argument they made in the Barnett case, and they've made this, I think, in other places too, but I'm just going to pick one example because it was a case argued by Harmeet Dillon, literally oral argument in the U.S. Court of Appeals for the Seventh Circuit in Chicago. And this is the brief that she wrote with several other prominent lawyers at the Department of Justice. Here's what they had to say in the brief, and you'll see how it specifically says we have the right to train because we have the right to maintain proficiency, citing to an important case called Ezell out of the Seventh Circuit, which literally says we have the right to train with firearms. Here's what the DOJ had to say in support of this proposition. Quoting James Madison, no axiom is more clearly established in law or in reason than that wherever the end is required, the means are authorized. The same principle holds true in the Second Amendment context. As this court has recognized in the past, the Second Amendment protections extend to certain important corollaries of the core right to possess arms for self-defense and other lawful reasons, citing to the Ezell case, which specifically says you have the right to train with arms. Several such corollaries receive Second Amendment protections. The right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use, and to purchase and provide ammunition suitable for such arms, and to keep them in repair. Then it goes on to say, listen carefully, folks, the right to keep and bear arms also involves the right to maintain proficiency in firearm use. Let me repeat that. The right to keep and bear arms also involves the right to maintain proficiency in firearm use, quoting the Ezell case from the U.S. Court of Appeals for the Seventh Circuit that said you have the right to train with firearms. That's exactly right. How on earth can we be proficient in firearm use without the ability to train? In fact, if you look at the Supreme Court's decision in Heller, also cited by the Donald Trump Department of Justice here, Heller specifically talks about the importance of training and being able to use firearms for various purposes. In fact, if you think about it, we don't talk a lot about the prefatory clause referring to a well-regulated militia being necessary for the security of a free state, right? We don't talk a lot about a well-regulated militia, but the Supreme Court actually does refer to and discuss what is a well-regulated militia. And because it was written in 1791, you understand that we have to go back to 1791 to understand what did those words and phrases mean in the minds of the public that ratified and adopted this amendment, what did they understand it to mean? And everyone, based on the dictionaries at the time and the legal language at the time, understood that the phrase well-regulated simply means proficient, efficient, effective. It works, if you will. Has nothing to do with a bunch of regulations promulgated in the 21st century, let's say by the Environmental Protection Agency or administration. It's nothing like that, no. A well-regulated militia in 1791 was just a functioning, efficient, proficient, useful, effective militia. And who was the militia? Well, there's a couple different ways to view the meaning of militia, but the bottom line is, at the time of the founding, the militia was all of the people. You had specialized militia, often referred to as the Minutemen, but that's not relevant for our purposes because at the time of the founding when the 1791 was written, and it refers to a well-regulated militia, the militia was basically all Americans, or at least all American men capable of bearing arms, right? So the reason why this is important is in order to ensure the existence, even today, of a well-regulated militia, meaning an effective fighting force, familiar with firearms, proficient in firearms, the ability to keep them in repair, to keep them working, to be able to shoot accurately, to use them safely, to use them effectively, to ward off all forms of tyranny. You have to be able to train and work on firearms. And often that can involve working and training with others or involving others collectively. All consistent with the prefatory clause of making sure that we in the United States have a well-regulated, meaning an effective militia. And beyond that, let's talk about the word the people. Yes, there's no doubt that the right of the people to keep and bear arms refers to an individual right. But the phrase the people comes up in multiple provisions, right? It comes up in the Second Amendment, I believe it comes up in the Fourth Amendment, it comes up in the 10th Amendment. In fact, it even comes up in the First Amendment, the right of the people. It's a phrase. So it means individually, yes, but also all the people. Collectively and individually. It's an individual right, true, but it can also be exercised collectively. That's why the First Amendment, Fourth Amendment, Second Amendment, 10th Amendment all refer to the people. So you take that phrase, the people, the understanding structurally of the Bill of Rights, and that it was intended to preserve individual rights, but also the ability of people to come together. Just look at the different things we've already talked about in context of, among other things, the First Amendment. And it's pretty clear that any sort of state laws by blue states and other states that somehow try to restrict the ability of Americans to come together to train to ensure proficiency and familiarity with firearms should fall by the wayside under, among other things, the Second Amendment itself. And the fact that the Trump administration is arguing and quoting favorably the U.S. Court of Appeal decision in Ezell, that's a very powerful evidence that the Supreme Court entirely agrees with what I should say, that the Department of Justice under Donald Trump and Pam Bondi agree with everything I just said on this very point. But it's not just Mark Smith, the Trump Department of Justice, and the language of the Constitution that proves the point here, that anti-militia laws should fall by the wayside as a practical matter. There's also Supreme Court language that literally touches fingers with this. Let's just take a couple examples from the Supreme Court decision in Heller, and you'll see what I mean. The prefatory clause of the Second Amendment does not suggest that preserving the militia was the only reason Americans valued the ancient right. Most undoubtedly thought it even more important for self-defense and hunting. That's what Heller said. And then it goes on to say, ready? Quote, there are many reasons why the militia was thought to be necessary to the security of a free state. Citing to Joseph Story, very famous, important judge. Goes on to say in Heller, when the able-bodied men of a nation are trained, bing, 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 hear what I just said? When the able-bodied men of a nation are trained in arms and organized, they are better able to resist tyranny. The U.S. Supreme Court in D.C. versus Heller in 2008. What can you say? The U.S. Supreme Court itself has said that the better Americans are trained in arms for, among other reasons, self-defense and thwarting tyranny, the more the meaning and purpose of the Second Amendment is satisfied. And never forget, when you talk about, when I use the word tyranny, I think a lot of people don't fully utilize the word tyranny as robustly as you should be doing so. What do I mean by that? The Second Amendment is there to confirm and reaffirm and codify a pre-existing right to self-defense using arms. Part of it, if not the main part of it, is the ability to use arms to thwart and deter and stop all forms of tyranny. And when I talk about tyranny here, that could include anything that attacks you or tries to threaten your life, the life of a loved one, the life of a community member, whatever it is. And that tyranny could come, yes, from a tyrannical foreign invader. It could come from a tyrannical domestic government. It could come from a criminal, a terrorist, a cartel member. And yes, as I've even written extensively about, it could even come in the form of an animal attack. But whatever, that's why when you talk about the Second Amendment is designed to thwart and deter and stop all forms of tyranny, never forget the range of tyrannical conduct and actors that encompasses. Everything from a rabid dog trying to bite you all the way up to tyrannical foreign invaders and everything in between on that spectrum of tyranny. So never lose sight of that. So when you talk about the Second Amendment is there to thwart tyranny, don't ever forget the broad scope of what a tyrant or what an act of tyranny might mean. Do not interpret it in a narrow, limited way. Understand it and articulate it in a broad way. Again, ranging from everything from an animal attack all the way up to an invasion by space invaders, if you will, and everything in between, including common criminals, gang members, cartels, and so on. If you do these things and go through what I just went over, that the Second Amendment protects the right to train, as the President, Donald Trump's DOJ, is articulating in these briefs, as well as the other points that I've made about the structure of the Constitution and the meaning of the Bill of Rights, as well as the Supreme Court precedent, you'll be well on your way to defeating any discussion in your state or local governments or areas about trying to thwart collective training together with arms. All right, folks, there you have it for today. Hope you enjoyed today's video. Make sure you follow me over there on X at 4boxofdowner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.